Morning, everyone. We'll give folks one more minute before we kick off. Okay, I'm reading 9:02 on my clock here, so let's get it underway. This is the third and final scheduled meeting of the 340B work group established by Connecticut Public Act 23-171. So if you're here to discuss 340B issues, you're in the right place. My name is Mehul Dalal. I'm the Chief Policy Advisor at the Department of Social Services. I'm joined by Joel Norwood, Deputy Policy Advisor here. Hopefully everything's okay on the technical side. If you want to give me a thumbs up there, Joel. Okay, great. So today we have a few presentations and we're hoping to sort of just finalize our meetings together as a group and give you some direction on how we will do that. We won't go around and do reintroductions, everyone, but we do have a couple of new participants, so I do want to give them the opportunity just to say hello, and I know at least one of them will have some remarks later, so I'll pass it over to Mr. Vigil if he just wants to introduce himself, and then we'll come back to you.
Sure, thank you. Hi, I'm Daniel Vigil. I'm Executive Director and Head of State Policy at Novartis, and I appreciate the opportunity to present to you all this morning.
And we have Jennifer Hers. I think I saw her name on here. She wants to introduce herself. Go ahead.
Good morning, everyone. Jennifer Hers from Beringer Ingelheim. I'm the Director of State Government Affairs.
Great, thank you for joining. Is there anyone who has not joined a previous meeting and wants to introduce themselves now? You can come off mute and just say hello. I'm scanning. I think everyone here has joined a previous meeting, so I think we'll be okay there. So I'm going to jump down to agenda item number 2 is a brief summary of the November 28th, 2023 meeting. As a reminder, the minutes and the recording have been posted on our 340B workgroup website. So if you want to see the full recording of the discussion and the summary minutes, those are available for you. I think, generally speaking, we've spent the bulk of the time last meeting listening to and then discussing a presentation by Bill Smith from the Pioneer Institute covering the history of the 340B program, the growth of the 340B program, and we had some good discussion based on that presentation. Again, the full recording is available as well as the minutes that summarize that discussion. We discussed a little bit about the process of gathering feedback, and after the meeting, I think everyone here, except potentially the newer members, received a proposed outline of the report and with the opportunity to submit any additional information they had that they believe was relevant to that outline. Did receive some feedback and indications that more would be coming. We will need to be pretty strict on the deadline, given the time it'll take us to prepare the report and run it through internal review. And we can talk a little bit more about the deadlines at the end. Excuse me, 1 minute. We do have an internal process, a review process that we will have to follow, and the date, our deadline to submit back to the legislature according to the provision is January 31st. Given vacations and holidays and people being in and out, we're going to have to get everything kind of wrapped up in terms of materials pretty soon. So today we're going to have presentations from the Attorney General's office, Mr. Vigil, sorry for mispronouncing your name earlier, and then a discussion of any other provisions that we'll have an open discussion if folks want to contribute anything else on the provisions, and then discuss our timeline at the end of the hour. So unless there's any other questions about that, we will pass it over to our first presentation, which will be from the Attorney General's office. And I don't know who's leading that. Is it you, Patricia?
I'm kicking it off. Yes, thanks, Dr. Dalal. And Joel, I just sent you an email. I'm not sure, do I have the capacity to share my screen, or could you share our deck?
Or if you could give me permission, Joel, I can also share.
There you go.
You should have permission. If not, let me
Okay. Thanks, Rahul.
why don't you give it a shot? And if it doesn't work, let me know and I will figure out what I need to do to.
All right, it says host disabled participant screen sharing. I can also just send you our slides really quickly.
I did. So
Okay.
All right, let me see if I can do that then. Oh, wait. Just give me a second. All participants. All right, try again.
All right. Can folks see my
Okay.
screen? See the PowerPoint?
yes.
Yeah,
Everyone
if you
else?
could switch to slideshow mode, it'll show up a little larger.
How do I do that?
No, from beginning, far left.
Oh. All right, does that look good? All right, Trish, I'll hand it over to you if the screen looks good.
Thank you. Does it look good, Joel?
If you could click on the slideshow, either the icon at the bottom or the from beginning on the far left, it'll just be, I mean, this slide is fine, but when there are more text, yeah, if you just click on that, it should work. And if it doesn't work, then it's fine just the way it is.
Okay. So
You'll
good
have to
morning,
share
everyone.
your entire screen versus just the PowerPoint. I think that's what's happening. So it's getting stuck on the PowerPoint, even though like the full screen presentation might be appearing on your screen.
Perfect. All right. Thank you,
You
Sabrina.
there? Okay. Thank you. Good morning, everyone. My name is Trish McCooey. I'm an Assistant Attorney General in the Health and Education section at the office. Happy to be here this morning. I'm going to briefly give a recap of the office's involvement with 340B issues over the past 3 or so years. And then I'm going to hand things over to Rahul Darwar, who has been actively engaged in these issues, and he is an AAG in the antitrust section. So just at a very high level, the office has been engaged in 340B issues because they have a significant impact on Connecticut citizens. The office recognizes and has been trying to protect the ability of covered entities to obtain 340B drugs, including their contracted pharmacies' ability to obtain 340B drugs, because it's viewed as something that enhances the healthcare system in Connecticut and protects and enhances the health of Connecticut citizens. The office first became involved in the issues in 2020 when a number of manufacturers started restricting or limiting access by contract pharmacies. And this was viewed as, and is still viewed as reflected in our amicus briefs on this issue, sort of a unilateral, unjustified action by the manufacturer to address something that they viewed as an issue. Rahul will also talk about state efforts to address issues related to the contract pharmacy issues and problems. And sort of another sort of major theme here, and something that the office supports, is the program is definitely at a crossroads. It's complicated. It's grown exponentially, and we do support efforts for HRSA to have enhanced resources, including funding and regulatory authority to run the program and administer the program. So, and there is a significant call from a number of quarters for greater clarity and strength in terms of regulation and enforcement. So, next slide. This is just a quick sort of timeline of our involvement. Again, it started by Attorney General Chong reaching out to the manufacturers, and then subsequently reaching out to HHS to, on behalf of a national or a multi-state coalition, to enforce to HHS our states and other states' legal views that the limitations on contract pharmacies was not legal. And then in 2022, last year, our office led a multi-state effort of AAGs to submit amicus briefs in 2 of the federal court cases that Rahul is going to briefly touch upon. Finally, this past July, Attorney General Tong was the lead author of a letter co-signed by a bipartisan group of attorneys general, I believe 20 or so. That letter was in response to the group of 6 or so senators that issued in June of this year a request for information seeking potential solutions, ideas for sort of the various regulatory and practical issues that were arising for 340B programs. The July 28th letter again emphasized a couple of themes. First and foremost, again emphasized the author's view that the contract restrictions were illegal. Also emphasized again the important role of the program for the citizens in the states that authored the letter. And finally, did acknowledge the need for greater support financially and congressionally, perhaps, of more regulatory authority for HRSA to lead and regulate the program in its, sort of newly expanded form over the past 10 or so years. So that's a very brief cap of where the office has been. Rahul is going to touch upon a couple of different areas of litigation across the country in which our office has been involved, either as a friend of the court author or in terms of actively monitoring state legislation in this area that's been challenged. So with that, I will hand it over to you, Rahul.
Thanks, Trish. As Trish mentioned, I'm Rahul Garwar. I'm an AAG in the Attorney General's office in the antitrust section. And along with my colleagues, Carla Tarikian and Kara Passero, we have been monitoring a few streams of 340B related litigation over the past 3 or so years. The 340B litigation can probably be bucketed into 3 categories. The first being the contract pharmacy litigation, the second, federal preemption litigation, and the third is what we call patient definition litigation. And I'll briefly describe these three large buckets of 340B related litigation. So the first set of litigation deals with, as Trish mentioned, contract pharmacies, and this is when in mid 2020, certain manufacturers starting imposing restrictions on the delivery of 340B drugs to contract pharmacies. That led to HRSA issuing what we call violation letters to those manufacturers, and then the manufacturers challenging HRSA's authority to issue those letters in federal court. There was a large amount of litigation across multiple federal district courts, and this litigation was consolidated in 3 circuit courts or appellate courts at the Third Circuit, the Seventh Circuit, and the DC Circuit. And all 3 of these cases asked the general question is, does the 340B statute allow require drug manufacturers to deliver drugs to an unlimited number of contract pharmacies? So far, only 1 court has ruled. The Third Circuit ruled that drug makers are not required to deliver drugs to an unlimited number of contract pharmacies. And we're still waiting to hear from the DC Circuit and the Seventh Circuit to rule on their cases, which oral arguments were held more than a year ago, and we're just waiting for those decisions to come down. The next set of litigation is what we call federal preemption litigation, and this is a little bit different. This deals with state laws. So there's thus far been 2 states, Arkansas and Louisiana, who have passed state laws that relate to the 340B program, and Pharma, the manufacturer trade group, and certain manufacturers have challenged those state laws on preemption grounds, saying that those state laws are preempted or are superseded by federal law in this area. The first and perhaps most notable is Arkansas Act 1103, which requires that manufacturers provide 340B drugs to contract pharmacies. And this was the first state 340B legislation that was passed in 2022. And the Arkansas Department of Insurance also issued implementing regulations related to the statute last year. This case started in Arkansas Federal District Court, and a federal district judge ruled that the law was not preempted. The state law was not preempted by federal law, but Pharma appealed that to the 8th Circuit, and oral arguments recently held, and we're still waiting for a decision from the 8th Circuit on if the Arkansas state law is preempted by federal law. The next case, which is very similar, is out of Louisiana. Louisiana very recently in 2023 passed a 340B, a state 340B law that requires drug manufacturers to deliver drugs to contract pharmacies. There's been 3 cases that have been filed, one by Pharma, the trade group, and one by AstraZeneca, and one by AbbVie. Those cases are currently undergoing briefings, so motions to dismiss. The state has filed motions to dismiss, and the manufacturers and Pharma are filing opposition motions to that. Arguments have not yet been held, but we're predicting or expecting arguments to be held in early 2024 in these 3 cases, which are in federal district court in Louisiana. And the final kind of bucket of litigation that we're seeing is what we call the patient definition litigation. And this kind of the landmark case here is the Genesis Healthcare case, which is in South Carolina Federal District Court. And this deals with the definition of who is of a patient for 340B purpose. Genesis appealed that decision to court, and the court very recently found that HRSA's limited restrictive interpretation of the statute was outside of its authority, and that HRSA should allow Genesis Healthcare to dispense drugs to a plain text definition of the term patient. So another area where there hasn't yet been litigation, but we're seeing some state law action that we've been monitoring is in states passing transparency requirements related to 340B. Thus far, 2 states, Minnesota and Maine, have passed laws requiring certain transparency for 340B covered entities. Minnesota's law requires all covered entities to report acquisition costs and payments received for 340B drugs, and what payments are being made to pharmacies. Maine only requires hospital covered entities to report, and they're required to report on their uses of 340B program savings and any data comparing their 340B acquisition price to drugs that they have acquired through other means. Both of these laws have not, as far as we know, have not yet been challenged. So we're keeping an eye on to see if these 2 state transparency laws will also be challenged by Pharma, the manufacturer trade group, or by drug manufacturers as well. So that was a very quick and high-level overview of some litigation and legislation in the 340B space. And Trish and I would be happy to answer any questions that folks may have.
Really appreciate that informative overview. A lot of good information there. So let's open the floor for questions and discussion. You can use the raise hand function if you can find it. If not, you can try waving. I'll try to call on you. I see Bill Smith with a question.
Just a quick question for Raul. Very informative and helpful presentation. My only question is, has the State Attorney General's office looked at the issue of duplicate discounts, whereby a 340B drug is dispensed medication, then a manufacturer is billed for Medicaid rebates, which is a violation of federal law, but there's some evidence that that's an ongoing problem in contract pharmacies.
Others from our office can jump in, but as far as I know, we have not looked into that in Connecticut, at least. At this point, we have not looked into that. And Trish, you may be muted if you're talking.
Oh, I am on mute. Okay. Yeah, our office has not been involved. I know as somebody who's been on both sides, I was at DSS for a number of years. I know they're certainly cognizant of the prohibition on double discounts. I'm not aware of any problems in that area, but I don't know if anyone from DSS wants to add to that. I will note that our Connecticut's program has a lesser layer of complexity since there's no Medicaid managed care here whatsoever. So, but we have not been involved.
Hi, this is Herman Kranz. So we have measures in place to make sure that there aren't duplicate discounts for the Medicaid program. Both HRSA and manufacturers always have the right to audit and look at what we are invoicing for rebate. So we use something called the Medicaid exclusion file, and that is provided to us through HRSA as far as those entities that are enrolled in the 340B program. If they're basically on that file, we are not allowed to invoice manufacturers for rebate. If they are not on that file, we do. Like I say, manufacturers, when we invoice for rebate, they certainly check and they make sure that we are invoicing correctly. So we have not had an issue in Connecticut with that because we do it all in one place. As Trish had indicated, we don't have MCOs, so we don't have multiple organizations that are billing for products or multiple agreements in place. We have the one, and it's basically a one-stop shop where we're able to, using edits and audits to make sure that we're billing correctly. Hope that answers your question.
Thank you, very helpful.
Any other questions for the Attorney General's office staff? Drew?
I just wanted to flag, really appreciate the presentation. Also, I think I mentioned this in one of the previous meetings, Washington State also passed a requirement that the healthcare authority out there develop transparency reporting for covered entities. It was buried in their budget language, so it's not as out there as the Minnesota and or the Maine bill are. But there is a third state that passed something this year, but it was in their budget. Thank you.
Thanks, Drew. Now that you say that, I did see a map on that a day or so ago with those 3 states up north. So,
and I can send that language to you, Tricia.
Okay, that'd be great. Thank you.
If you could send it to either myself or Joel as well, that'd be great. Absolutely. Thanks.
As well as the language from the other 2 states, we can include that as part of the documentation that will circulate to everyone.
I'll send a link, and I think I said last time that we did have a slide. I put together a side-by-side comparison that I can send around to the bigger group. I just
That'd be great.
Thank you.
All right, any other questions or discussion before we move on to the next agenda item, which is a presentation by Mr. Vigil? Okay, I don't see anyone with their hands raised or waving. So we'll turn it over to you, Mr. Vigil.
Thank you. Just a reminder, Daniel Vigil, Head of State Policy at Novartis. Going to start off with an introduction to Novartis. I'll discuss some of our concerns with some of the growth of 340B contract pharmacy arrangements, and then I'll close with a few reasons why we think states cannot and should not place 340B contract pharmacy mandates on manufacturers. So let me introduce you to Novartis. We provide healthcare solutions that address the evolving needs of patients and societies worldwide. We are a focused medicines company concentrated on the core therapeutic areas of cardiovascular disease, immunology, neuroscience, and oncology. We are united by a single purpose to reimagine medicine to improve and extend lives. Novartis supports policy solutions that improve patient access to medicines, including policies that support the healthcare safety net. As a long-standing participant in the 340B program, we support the program. We believe it can play a role in expanding healthcare access and affordability, particularly for low-income and underinsured or uninsured patients. Nevertheless, lax federal oversight is a problem. It has caused the 340B program to grow rapidly, and we believe inappropriately, particularly in recent years, with no evidence that patients are benefiting accordingly from this growth. Once a relatively small program, 340B has now become, and I know you guys heard this earlier with previous presentations, but become the second largest federal drug program today, with discounted sales of almost $44 billion in 2021. So given the size of this program and the well-documented corresponding rise in program integrity concerns, we do believe strongly that reform at the federal level is essential to refocus the 340B program on its mission of enhancing patient access to affordable prescription medicines. So let's take a deeper dive now into some of our concerns with some of the growth in contract pharmacy arrangements. So I'm going to start with some data points. Since 2010, the number of covered entity contracts with pharmacies has grown by more than 8,000%, with roughly 33,000 pharmacies participating in the program today.
Mr. Vigil, I don't know if others are having, I'm seeing a little connection issues. It might be on our end, but I want to make sure all of your words are captured in the recording. So the past 30 seconds or so, the connectivity has been a little limited.
All right, apologies. So for those who missed it, I introduced Novartis, the group, and now I'm going to start off with some data points on some of our concerns about the growth of contract pharmacy arrangements. And I'll hold my microphone close, so hopefully that helps. So first data point, since 2010, the number of covered entity contracts with pharmacies has grown by more than 8,000%. And there's about 33,000 pharmacies participating.
I'm having network issues on my end, even though I'm
okay.
For what it's worth, Joel, I hear him perfectly.
In the office. And others,
yeah.
Fine, I just connect.
Are we good to go?
Sorry about the connectivity issues. Why don't you just keep going from where you were and
all right.
Sorry about that.
Thank you. No problem. All right. So in Connecticut, there's 16 hospitals that are part of the 340B program. Yet there are 1,401 contracts between those 16 hospitals, 340B hospitals, and pharmacies nationwide, including some pharmacies as far away as California, Nevada, Hawaii, and Texas. and only 19% of these contract pharmacies are located in medically underserved areas. So let me repeat that. Of the 1,401 contracts between Connecticut's 16 340B hospitals and pharmacies across the country, only 19% are with pharmacies in medically underserved areas. So additionally, under contract pharmacy arrangements, contract pharmacies can share in 340B revenues with no strings attached, including charging an uninsured individual the full cost of the medicine, which obviously greatly benefits these for-profit pharmacies financially. And it's important to note, we really want to stress for this work group, that profits from contract pharmacy arrangements accrue not just to 340B covered entities, but a robust ecosystem of for-profit entities, including third-party administrators, software vendors, and the contract pharmacies themselves, which are often a large pharmacy chain or are aligned with a large vertically integrated pharmacy benefit manager or PBM. So, some more data points. More than half of the 340B profits retained by contract pharmacies are concentrated in 4 large for-profit pharmacy companies: Walgreens, Walmart, CVS, and Accredo, which is owned by Express Scripts, which is owned by Cigna. And in fact, both CVS Health and Walgreens have noted publicly in their earnings calls that 340B is a driver of their profits. And recently, the research from firm BRG estimated that as much as $10 billion in profits will be captured by for-profit pharmacies this year from 340B. So again, PBMs often own or are otherwise affiliated with these contract pharmacies. So today, 46% of contract pharmacy arrangements are with pharmacies affiliated with the 3 largest PBMs: Optum, CVS, Express Scripts. And according to the firm Nephron, PBM-owned or affiliated contract pharmacies are estimated to retain $2.58 billion in 340B discounts in 2022 from, of course, what is a healthcare safety net program. One more call out. In addition to owning many of the contract pharmacies, especially pharmacies, PBMs also own the leading third-party administrators, or TPAs, that many covered entities use to adjudicate the 340B claims. So CVS owns the TPA WellPartner, Cigna owns Verity Solutions, and Walgreens owns Complete and Shields Health Solutions. So this is my final point. I'm gonna list off some reasons why we firmly believe, states should pause and not adopt mandates on manufacturers with regards to 340B contract pharmacy arrangements. So first, contract pharmacies are not mentioned anywhere in the federal 340B statute, and the concept of contract pharmacy was developed in 2010 solely through federal agency guidance that does not have the force and effect of law. And establishing the 340B program, Congress did not provide for a role for states to define its parameters. Second, the federal government has a complex and pervasive statutory and regulatory regime in place that governs the 340B program and all its parameters. So the program is nationwide, it's administered nationwide, and it applies nationwide. And states that introduce an Arkansas or Louisiana style manufacturer mandate that different from the federal directives, they really prevent a very real risk of creating an unmanageable patchwork of requirements for manufacturers, subject to both federal and state mandates that may align or they may differ. Third, as this work group has already heard previously, Arkansas and Louisiana laws that purport to require manufacturers to provide 340B pricing through contract pharmacies are being challenged as unconstitutional in federal court. And most importantly, want to stress, forcing manufacturers to extend 340 pricing to any contract pharmacy without limitation, it's going to further distort the 340B program. It would essentially codify in state statute the ability of for-profit pharmacies and PBM conglomerates to generate billions off a healthcare safety net program. Yet there's no evidence that this would actually benefit the lower income uninsured or underserved patients that 340B is intended to serve. So, couple more data points. A report from the U.S. Government Accountability Office, or the GAO, found that more than half of 340B hospitals, again, speaking to hospital-covered entities, did not share discounts with patients at their contract pharmacies. So patients there are not benefiting. The Journal of the American Medical Association, JAMA, released a study that found contract pharmacy growth from 2011 to 2019 is concentrated in affluent communities who have robust employer-sponsored insurance, as opposed to socioeconomically disadvantaged communities that Congress created 340B for. So, really want to stress that contract pharmacy arrangements, they divert program savings from their intended use, benefiting vulnerable patients, and they are currently increasing the profits of commercial middlemen like PBMs. So I will conclude here. Want to say thank you for allowing me to present this morning. We, Novartis, I personally, we understand the complex challenges confronting the 340B program, and that this work group is charged with studying. So we appreciate your work, and we stand ready to assist going forward. Thank you.
Thank you, Mr. Vigil. And at least on my end, we heard all your comments loud and clear, but in case that didn't capture on the recording, if there's any possibility for you to submit anything written, if you have the time, that would be helpful, just in case we missed some of it on the recording.
I'd be happy to. Thank you.
Okay, that'd be great. Appreciate it. Let's open the floor for questions and discussion. I'm just going to scan the second page in case I'm missing anyone.
Mehul, sorry, it's Paul Kidwell, the Connecticut Hospital Association.
Go ahead.
Just a question about the definition of medically underserved. I'm just interested in what you, if you could share that definition of medically underserved and where that is sourced from, either the 340B statute or HRSA regulations.
I'll submit the citation in my written response, but it was pulled from the pharma report cross-referenced the HRSA data in terms of number of contract pharmacies, and then cross-reference it with a separate data source for medically underserved communities. I'll provide that citation to the workgroup.
Thank you.
Sure.
Sabrina?
Good morning, everyone. So, Daniel, thank you. I do have a question though. So Novartis is a for-profit company, correct?
Correct.
So by restricting access to 340B drugs at contract pharmacies, Novartis is paying less discounts, 340B discounts out. So that money that was being spread across to underserved patients, uninsured patients, is now going back to Novartis and staying in Novartis's pockets, correct?
Novartis supports a variety of patient assistance programs, and we also are participants in a number of federal programs, which provide access to discounted drugs, including Medicaid, 340B. So I don't think there's a direct correlation from one to the other.
So
we invest in patient assistance of a variety.
Okay, so for patients that have unstable housing situations or can't read, can't write, can't in their own language, right? Patient assistance programs and applying for that and all of the document requirements are rather difficult. And if they don't have stable housing situations, how can they get medicine directly from Novartis?
I want to also draw the distinction from 340B to those patient assistance programs. They are separate, but we do have a hub that actually helps connect patients with the appropriate assistance that they are eligible for.
But by taking this stance, right, as a drug manufacturer, you've essentially decimated that program for patients that can't access a single in-house owned 340B contract pharmacy, specifically in the FQHC realm, right? So I realize that big pharma and contract pharmacies and all of that, there's a whole slew that needs to be kind of analyzed and gone after in that sense. A lot of, you mentioned it, like the big three, big four, they force patients to use their pharmacies, and then if it's a specialty medication, it's filled at certain locations, but then the patient is ultimately able to pick it up at their local pharmacy. So a contract pharmacy may not necessarily be in an underserved area, but it might just be the way that the pharmacy is forcing patients to use that network. So by applying these standards and these restrictions, our patients, for example, we have 13 medical sites that are across 3 different towns in the state of Connecticut. Just speaking for First Choice Health Centers, if a patient can't get to our location in East Hartford, their hands are effectively tied. So I just want everybody to keep that in the back of their mind, that there are large blanket restrictions that have been placed, that the idea of them sounds really great, but when you're actually looking at what affects the patients and the residents of the state of Connecticut, they are really being cut off pretty substantially if they don't have insurance. Like I said, have unstable housing situations, don't have phones, what have you, don't necessarily qualify for state Medicaid. They're stuck, their hands are tied. They can't necessarily get to patient assistance programs if 340B access has then been cut off. So I just want everybody to kind of keep that in the back of their minds.
And Sabrina, I appreciate that. Just very briefly want to respond to 2 things. We do not believe we've decimated the program. We're calling for federal reform, and we hope that all stakeholders involved join together on what's workable at the federal level. And then secondly, from a Novartis perspective, the guardrails that have been implemented within our contract pharmacy policy, they don't apply to FQHCs. So we are a company that are not providing those or implementing those restrictions, or we have not implemented those restrictions on FQHCs.
And that's fair. That's fair. But in the grand scheme of things, right, which is what we're going through for this work group, and I apologize for calling you out and making a little bit of an example here, right? But for the larger aspect, and there's, I think, only a handful of drug manufacturers that do not apply to FQHCs. But
we're one of them.
That's my role here. Correct. That's my role here. And who I'm representing is the FQHCs in the state of Connecticut and our patients across the state. So thank you.
I see a couple hands up, but I saw Senator Summers with her hand up before, so I just want to make sure that didn't give her the opportunity if she would like to comment.
No, I had a comment on FQHCs, but I think I'll wait on that till later, and my question was answered. Thank you.
Sure. Keith.
Thanks very much for that helpful presentation from Novartis. Just a clarifying question. Does Novartis have a position on the transparency legislation that some states have put forward? The 340B transparency legislation.
We do believe there generally needs to be greater transparency, right, in how patients, low income, uninsured, underinsured patients are benefiting as Congress intended from the 340B program. We personally don't have a specific position on either of those 2 laws. And quite frankly, I personally haven't looked very deeply into them. So generally support the intent, though, of greater transparency.
Felipe?
Yes, I just have a quick comment, just picking on what Sabrina said. Felipe Moreno, 340B Program Manager at Community Health Center. Thank you for your presentation. So I'll just say that for contract pharmacy and uninsured patient, proximity matters. Patients already make a huge effort to go to one of our 14 locations, and if they don't have access to their medication close to their living space or where they can really afford to get to, then it will mean the world to them if that is, being taken out or removed for their options. So just kind of, I'm just speaking, from the ground here because we do that work. We see like 32,000 prescriptions a year for uninsured, and most of the manufacturers have logged access through only one single store, which is, pretty much cut everything to going in that direction. So that's really affected our patients in the access of medication. So I know that you don't, Novartis is not affecting directly to FQACs right now, but we have seen that eventually they will restrict FQACs, and we have seen that with some other manufacturers as well. So we're kind of like counting with that workflow in the future. So not really sure how that is supporting our patients, and just again another perspective of this. So like the total amount of medication that we serve through or contract pharmacies, we do have the probably one of the lowest fees for them. So we really are trying to expand that benefit the best way that we can to our patients.
Thank you. Paul, I think your hand was up next.
Yeah, just one additional question. Just thinking through the outside of the 340B program, the pretty significant discounts manufacturers provide to PBMs. Can you talk a little bit about then the concern with providing the discounts to the not-for-profit covered entities? I'm just trying to wrap my head around the sort of concern there.
They're absolutely not related, and I don't think it's it's important to definitely draw distinctions where they must rest. So first of all, our concerns with PBM market power, how they leverage themselves within respective avenues of our healthcare system, that part spills over from one program to the next, from the commercial marketplace to public programs. So in the same way that PBMs have inserted themselves into a healthcare safety net program like 340B, they have also inserted themselves into the way commercially insured patients access their necessary medications through their health insurance plan formularies. And they use their leverage to demand discounts from manufacturers. And just like in some aspects of 340B, those PBMs are not sharing those discounts with patients. So, they're separate from a legal and policy perspective, but our concerns with PBM behavior hits both sides.
Thank you.
Any other questions or discussion points? Okay, I'm just doing a quick scan since I'm relying on people waving their hands. All right, I don't see anything. So let's move on to the next agenda item. Appreciate the discussion on this one and your presentation, Mr. Vigil. So I think it was a good discussion. The next agenda item is actually more of an open item in case folks want to bring anything else to the discussion with the other provisions of the Public Act 23-171, or section, which is section 16. So really just anything else pertaining to those sections that folks want to bring to the table today. And I know we covered a lot already, so if not, that's also fun. I don't know if Joel, if you have quick access to the bill. I know you drop it in the chat all the time, but if you have quick access to it, to drop it in the chat just so folks can take a quick look at the provisions in case they want to jog their memory. While we do that, I'll just skip to item 6 in terms of the feedback. I think most of you, again, if you were on the list before you were added as a new participant for this meeting, you should have received an email from me with the deadline indicating last week, a December 15th close of business deadline for other information that you'd want for us to consider to put in the report. We've also decided that whatever you do submit, we'll go ahead and add as an appendix, even though it may not be part of the body of the report as is. So all of that information that you send to us can be included in the final product. We have as I mentioned at the top, we have a deadline of the 31st of January to submit this to the legislature. Can be a fairly long process of internal review, depending on how people's schedule go. Thanks, Jill. That is in the chat now, folks, just in case people want to take a quick look. So we are asking sort of a last call for information the end of this week. That's Friday, close of business. I know some folks indicated that they were intending to submit something, but may have run out of time before the last deadline. So we will give folks till the end of this week, and then our team has to get together internally to start preparing the report itself. Any questions about that process? Okay, we'll send a reminder out just so you'll have it on email about that new deadline. We will, folks who have submitted things and that have not been distributed, unless we hear otherwise from you, we'll go ahead and distribute those materials to the group as well. Paul, I think I'm referring to your submission in general. We have not shared that with the whole group yet, but we're happy to do so unless you have some objection to that.
No, please do. Thank you.
Heather from OPM.
Hi, thanks so much. Just a quick question about the next steps. So you've extended the deadline for input, and you'll be putting together the report, having internal review, and to submit to the legislature by the deadline of January 31st. Will there be other opportunities for this work group to sort of look at the report, the draft of the report before it goes to the legislature?
Happy to discuss that, and I might defer, sorry to put folks on the spot, the folks who have been through this process before. Our internal review accounts for the OPM review timeline as well, so maybe we can discuss that. And
just
then
to know if this group as a whole would have a chance to submit feedback, or it was just going to be internal to state agencies.
I think we're mostly, as Dr. Dalal alluded to, we're mostly just very acutely aware of the calendar and that there's limited time, that a lot of people will be away next week, obviously, and wanting to make sure there's adequate time to gather the feedback. If that all goes more smoothly and more quickly than it usually does, given everyone's many competing commitments, we can certainly revisit that. It just seemed unlikely that there would be time.
Thanks.
Paul?
Sorry, just on that sort of time for review and related to the characterization, I guess, in the report, then I assume then it would just be characterized as DSS's views of the work group deliberations, or how do you intend to characterize the report?
Well, the statute is very specific that it's DSS writing the report, not the working group. So the formal report, as the statute says, it'll be DSS's report informed by the work group. And our intention is to attach all the materials we've received from everyone as an appendix to the report. So that's why we appreciate, Paul, that you already sent written materials, and anyone who's already sent presentation documents, that's all part of that same record. And that's why we strongly encourage everyone else who has anything they'd like to submit in writing. We strongly encourage you to do so, because then you'll be part of the appendix to the report. But no, we're not going to be saying anything about what the work group as a whole, and the statute doesn't contemplate that. It's just DSS, Commissioner DSS shall issue a report. That's all it says.
Got it. Thanks, Joel. I appreciate that clarification.
Hi, this is Jennifer Hers from BI. Will there be any other opportunities for oral comments? Or only written comments? I'm just wondering, kind of I know it's a tight timeline to get this done by.
Yeah, this is the final planned work group meeting. I think we kind of laid that out at the beginning of the process. So I think the best way to get input in would be in written format right now.
Okay. Yeah, I think the challenge, just to kind of share it, I guess for the record, was again, I'm talking for hers from Beringer. You know, if only a few months to come before the committee, 2 months, it's sometimes challenging to get approvals and everything that we need to get on our side ready to present in that tight time period. But I know Beringer is very interested in giving feedback and helping, you know, be a resource for this work group. I don't know that we'll be able to switch gears to provide written feedback in the next few days, kind of given the holidays that you had mentioned earlier. I'm kind of talking out loud here. Is there any other avenue for us to be able to be helpful?
Well, I think the deadline that Dr. Law was referring to is in order for DSS to be able to have the time to consider everyone's submissions. That's what we were initially saying this past Friday. We've extended it to this Friday due to our own time constraints. Of course, anyone is free to send anything at any time. It's just that we can't promise that we'll have time to analyze it, digest it, and so on. But so this statute has a specific January 31st deadline, but you can certainly send anything you want at any time. But I don't know. I'm just, all we're saying is that we can't commit to, we realistically won't have the time to commit to analyzing it, thinking about it in any real way if it's much later than the end of this week. So I hope that helps. It's just, we're trying to be realistic about our own capacity constraints. But Dr. Dahl, I know you were saying earlier about that, so I defer to you to elaborate.
Yeah, no, I think what you said is correct. So yeah, if you want to send us something after the deadline, I think, you know, we can look at it. Again, I don't know if we'll have the capacity to process it and put it into the report. Any other questions about process? All right, we're actually at the end. I know there was a brief item for other business. We will open 1 minute for that before adjourning. Any other business that people want to bring to the floor? All right, hearing none. Thank you very much for your participation on this. I know I'm speaking personally, I learned a lot about this very complicated program, and we only scratched the surface. So appreciate everyone's time, input, those who gave presentations, those who have thought about it. We will follow up with an email indicating the process and the deadlines, and enjoy the rest of your day and have a great holiday for those who celebrate.